A judgment.
Judgment item 3 from Supreme Court, First Appeal 138 of 2023.
This appeal is dismissed.
Passport case from Supreme Court is item 13, Second Appeal 571 of 2015.
Yes, can it be sent for mediation? You're for the private party.
स्टेट
भेजना है नहीं भेजना है?
इंस्ट्रक्शन वैसा नहीं और ये 1991 से सूट फाइल टाइटल फॉर डिक्लेरेशन ऑफ टाइटल है.
अच्छा.
It is not possible.
ठीक.
today.
The counsel for the respondent has submitted that the matter may not be sent for mediation. कब करेंगे बताइए? आप अभी भी कर सकते हैं. आप बताइए कब करिएगा? बहस तो आपको करना है.
मार्च में
With the consent of the learned counsel for the parties, pose this case for the final disposal on 30th of March.
From supplementary this case item 1, Second Appeal 352 of 2004 along with item 2.
Nobody appears on behalf of the appellant. On behalf of the parties. However, at the instance of the respondents, an adjournment notice has been circulated. Pose this case for final disposal on 25th February.
This case for final disposal item 4, Second Appeal 328 of 2016.
Yes, appellant.
They had circulated a letter yesterday.
I've already adjourned it. It is on 25th of February. Yes, who is for the appellant in this case? SA 328.
328.
You come on the next day. They have circulated for medical reasons. They have circulated.
Yes, they sent it to me late yesterday. The supplementary was late, so.
On 25th, you do.
Bye.
Appellant, are you there in this case?
Item 4.
This is plaintiff second appeal. This is the plaintiff has brought for declaration of right title interest and condition of position and alternatively for recovery of position. The case of plaintiff is that there are two sets of plaintiffs. First plaintiff.
This is title suit of 91. Right? First read the substantial question of law.
first semester question was whether the concurrent finding of both court will suffer from perversity due to non-consideration of issue involved in this case on the basis of evidence oral and documentary produced by the parties. Secondly, one is whether the court below have recorded finding beyond the pleading evidence of parties about identity of the sued property. And third is whether the appellate court below have recorded legally wrong finding in the instance of miscellaneous case number 105 of 8/2/1965 against the plaintiff's second set and held all preemptive as non-suited.
Now you read the judgment. Here there are plain written statements.
The defects of the plaintiff's case is that there are two sets of plaintiff.
You read the. I come to that. There are two sets of
Plaintiff.
plaintiffs. Okay.
Set. The first set is Ram Naresh Dubey and Ram and Bigal
Ram, Naresh,
Dubey and Bigal.
Dubey and
Ram Naresh Dubey and Bigal.
B-I-G-A-N.
B-E-G-A-N.
B-E-G-A-N Dubey.
Have claimed the suit property within plot number 78 and area 10 acre.
10 acre or 10 decimal?
10 acre. And in plot number 73, about more than 3 acres. And in plot number 96, about 1 acre, all within village Gamtaria. Initially recorded in the name of their father Chandrika Dubey and Rajkishore Dubey.
Recorded in the name of?
Recorded in the name of their father Chandrika Dubey and Rajkishore Dubey. Thereafter,
Just a moment. Chandrika Dubey and Rajkishore Dubey, are they related?
yes,
They are the brothers.
yes,
And these two persons, Ram Naresh Dubey and Bigal Dubey, they are the sons of?
son of Chandrika. Ram Naresh Dubey is son of Chandrika Dubey.
Okay.
Let me Ram Naresh Dubey is son of Chandrika Dubey and Bigal Dubey is son of Rajeshwar Dubey.
Rajkishore Dubey.
Yes, Rajkishore Dubey. Thereafter, there is a rent. Rent was sorry.
Just a moment. The learned counsel for the appellant has submitted that the suit was filed seeking right, title, interest, and possession.
Yes, right title and position, and also for recovery of position.
Okay. Good. Just. Seeking declaration of right, title, and possession with respect to the suit property and also for recovery of possession if found dispossessed from the property. He submits that there are two sets of plaintiffs. One from the branch of Ram Naresh Dubey. And the other, there were two plaintiffs, one Ram Naresh Dubey, son of Chandrika Dubey, and Bigan Dubey, son of Rajkeshwar Dubey. And the property was recorded in the name of Chandrika Dubey and Rajkeshwar Dubey, who are brothers. The property involved in this case is khata number 95.
96, खाता number 25.
Khata number 25, plot number 96, area 0.38 acres. Khata number 3,
97.
plot number 97, area 0.59 acres. Khata number 1, plot number 78, area 1.53 acres. And khata number 1, plot number 78, area 1.1 area 1 acre, total 3.50 acres. And boundary of the property has been given in schedule. The details and the boundary of the property has been given in schedule A. He submits that. The schedule B and schedule C are part of schedule A property.
Schedule B and Schedule C are the part of the schedule.
Yes.
Schedule B is of 1 acre, that is owned and possessed by the plaintiff's second set, and Schedule C is owned and possessed by the plaintiff first set.
Schedule B is owned and possessed by plaintiff.
Second set.
Second set.
And Schedule C is owned and possessed by
Second set represented by Bigan Dubey.
second set Ghura Dubey, substituted by his legal heirs.
That's right, but originally Bigan Dubey, no?
No. Schedule B Ghura Dubey.
Acha. Okay. Schedule B property is was owned and possessed by plaintiff second set.
Second set.
And Schedule C property was owned and possessed by
Plaintiff first set.
plaintiff first set. So consisting of Ram Naresh Dubey and Bigan Dubey. So far as plaintiff second sets are concerned, they are all sons of the original plaintiff number 3 was Suresh.
Ghura Dubey.
One second. Okay, the original plaintiff number 3 was Ghura Dubey,
Ghura
Rajwal, and he was substituted by his legal heirs. Was he? And Ghura Rajwal was the plaintiff second set. And the sole defendant was Bandhiya Rajwadin. How is she related to the plaintiff second set? Is she related?
No.
Title same है इसीलिए पूछ रही हूँ.
No, sir, not related. She was residing in her market.
Okay.
Outside.
You see, the recorded tenants are Chandrika and Rajkeshwar.
हाँ, उनके
दुबे.
in
तो
their
ये घूरा राजवार कहाँ से आ गया बीच में प्रॉपर्टी में?
ये record actually the land was recorded as Garuda Malik. That was not recorded as Garuda Malik, and the rent was assessed in their names.
Okay.
Assessed in the name of Chandrika Dubey and Rajkeshwar Dubey, relating to the Schedule C, and relating to Schedule B, the rent was assessed in the name of Ghura Dubey.
अभी आपके जूनियर ने बोला कि recorded tenant are Chandrika Dubey and Rajkeshwar Dubey. It is incorrect.
No. Recorded tenant means recognition of tenancy.
Recognition of tenancy और recorded tenant में फर्क होता है, दोनों एक ही बात है क्या?
नहीं, दोनों बातें नहीं है. लोगों ने उस चीज को नहीं क्लैरिफाई कर पाया. Recorded.
ये मत लिखिएगा भाई, recorded tenant का नाम ऐसे मत लिखिएगा, चंद्रिका दुबे एंड राजकिशोर. जमीन किसके नाम से recorded?
जमीन केस ये है.
देखिए बेसिक चीजें थोड़ा हमको.
हाँ ठीक है, बेसिक चीज ही बताते हैं.
जमीन किसके नाम से recorded?
थोड़ा प्लेंट क्योंकि थोड़ा इसमें है, यही तो डिस्प्यूट बस इसी के ग्राउंड पर तो नॉनसूट हुआ है.
चलिए पढ़िए.
हाँ, प्लेंट ही पढ़ देते हैं. प्लेंट बड़ा थोड़ा प्लेंट है. पैरा 1 में that Chandrika Dubey and Rajkeshwar, the sons of late Vyavahari Dubey, reclaimed about 10 acres of land. Reclaimed about 10 acres of land, plot number 78, more than 3 acres of land, plot number 73, and about 1 acre of land in plot number 96 of village Ginti. The rent for the above land was assessed and correction slip was issued on 8/2/65 in case number 105. And accordingly, rent from the date of vesting is being realized. Further, that in the name of Chandrika Dubey and Rajkeshwar, rent of other Bakas land, including 2 acres of plot number 97 was assessed. in para first and para 2. What illegality that has been committed, that is apparent from the same. In para 1, it had been clearly stated, pleaded, that rent for plot number 78, plot 73 and plot 96 was assessed through case number 105, not plot number 97. And in the suit, plot number 97 is also included.
ये जो 2 में जो है,
Para 2 में है,
para 2 में है,
हाँ, name that in the name of Chandrika Dubey and Rajkishore Dubey, rent of other Bakast land, including 2 acre of plot of 97, that was Bakast.
this was Bakas.
Bakast.
Okay. So it was never your case that plot number 97 was included in case number 105.
हाँ. And the court had dismissed the suit, holding that the same and further that
Next sentence. ठीक है.
that further that thus Chandrika Dubey and Rajkishore Dubey were recognized as occupancy legal with several acres of land covered by last cadastral survey plot number 96, 97, 73, 78 and others by the state of Bihar, and after their death the plaintiff's first set, being their exclusive heir, inherited the same and are in active cultivating possession of all documents. They are claimed the same through inheritance. Similarly, plaintiff's second set reclaimed 1 acre of land in plot number 78, for which rent was assessed in his name and demand had been opened by the state of Bihar in his name, and the realty rent is being realized from him from the date of this.
78 is common.
78 is common, but this is the case of second set is also as pleaded in the plaint that rent was also not assessed in the name of second set through case number 105.
लेकिन इसमें कुछ एरिया वेरिया कुछ नहीं दिया.
Up that what has been pleaded
78 इसमें भी है
और 78
और
इसमें
78 इसमें भी है.
इसमें उनका 1.5 एकड़ है, इसमें अपार्टमेंट सूट लैंड 1.5 एकड़ इनका 1 एकड़ है.
लेकिन इसमें कुछ लिखा नहीं.
इनका केस नंबर नहीं लिखा है, लेकिन कोर्ट ने ये डिसमिस कर दिया कि 105 हमारे पास प्रोड्यूस नहीं किया.
This is the purpose.
And 97 has been also included. Moreover, further, the important fact is
78 and 97.
97. Furthermore, the important fact is that the grounds, the points for determination as formulated.
एक second, just a moment. The learned counsel for the appellant has referred to para number 1, 2, 3 and 4 of the plaint, which is as under. इसको quote कर दीजिए. He submits that it was never the case of the plaintiffs that plot number 97, as mentioned in paragraph 2, and plot number 78, as mentioned in paragraph 4, where subject matter 78 तो है उसमें.
हाँ सूट में है.
नहीं, पैरा 1 में है.
हाँ पैरा 1 में है.
हाँ. आप बोलते हैं कि 78 नहीं था उसमें.
78 second set का नहीं था.
अच्छा.
Second set.
It was never the case of the plaintiff first set that plot number 97 was included in the in case number 105, and it was never the case of plaintiff second set that plot number 78 was included in case number 105. ऐसे कैसे सेग्रीगेट करेंगे? दोनों का कॉमन प्लेंट है, कैसे सेग्रीगेट करिएगा?
अब सेग्रीगेट इसलिए होगा कि दोनों का
कोई बात नहीं, आपका सबमिशन नोट कर लिया. सेग्रीगेट नहीं हो सकता ना, कॉमन प्लेंट फाइल किया.
हाँ कॉमन प्लेंट तो प्लेंट कॉमन है, लेकिन बट
78 तो है ही आपका.
हाँ but the points that have been taken by the lower
We'll see that. प्लेंट में और क्या दिखाना है बताइए. और रिटन स्टेटमेंट भी साथ साथ दिखाइएगा.
हाँ साफ दिखा रहे हैं. फर्दर the para 5 is also
ये कॉज ऑफ एक्शन है आपका.
the cause of action, and the necessity of, and the description of the suit.
Other section was not pleaded.
यही है section 144. वो तो substantial question of law भी नहीं है.
That was one of the amendment they have brought before the trial court. That was
Cause of action means bundle of facts which is essentially to be proved by the
coming
plaintiff.
the judgment. It has come to the judgment and maybe allowed to read it.
Cause of action is bundle of facts. And then
ठीक है,
defendant-
section
the-
144.
Defendant got a proceeding under section 144 CRPC initiated before sub-regional magistrate Garhwa against the plaintiff Ramnaresh only against Ramnaresh, which was registered as Miss Case 290 of 1986. In that proceeding, the defendant claimed the land described in A below hereinafter called the suit land as her relative, and wrongly alleged that suit land appertained to cadastral survey plot number 78. In that proceeding, she alleged to have acquired the suit land from the ex landlord in the year 1948 by Sada Bandwasti. She alleged that one correction slip in case number 7 of 8283 of the sub-regional officer Garhwa was issued, but the learned sub-regional officer, considering the entire documents of the plaintiff and the defendant, made the rule absolute against the defendant and vacated the same against plaintiff. तो इनके अगेंस्ट में एब्सोल्यूट हुआ, हमारे अगेंस्ट में वेकेट हुआ. Not being satisfied with the order in question, the defendant re-agitated the matter and got a proceeding under section 145 CRPC initiated with respect to the suit line against plaintiff both sides. This was registered as this case number 675 of 1986. In that proceeding, both parties filed their written statement, examined their witnesses, and filed documents, but on wrong appreciation of the facts and law, Sri Kailash SO, Executive Magistrate Garhwa on 24/12/88 declared the position of the defendant. Against that said order, plaintiff filed criminal division before the session del Pramwe Tribunal, which was registered as criminal division number 1 of 89, and the learned court was pleased to dismiss the division. Hence, the necessity for the suit. The necessity for the suit was the order passed in the proceeding under section 145 CRPC, confirmed in the division. That further, it has been stated that though in the proceeding under section 144 CRPC, the defendant has alleged that she had taken settlement in 1948, but in her examination before the executive magistrate on 3/5/87, she alleged that she took the settlement in 1954 from Bhaiya side. She gave her age on 35/87 as 40 years. Thus, she was born in 1947, and so she was just a minor of very tender age when Jamindari of Bhaiya side vested in the state of Bihar in 1951. Therefore, there is no question of any settlement of the suit land by Bhaiya side with her, and her entire claim about any settlement and possession was just the defendant claimed the suit land appertaining to the resource survey plot number 78 within the boundary as described in notice within the boundary as of the resource survey map. The portion of plot number 96 and 97 are also included. The defendant had filed a petition before the circle officer for demarcation of suit land, which was registered as demarcation case number 12 of 8889. In the demarcation report dated 10/8/88, it had been mentioned by the Amin within the boundary of the portion of Palestine Survey Plot 96 and 97 are also included within the boundary, and so the defendant's claim is apparently false. He also reported that within the boundary of portion of Plot 78, area 153 belonging to plaintiff first state, it is also included. However, he demarcated the remaining portion of foot land in the name of defendant. Though such land is exclusively to the plaintiff's second state, the Amin gave the revisional survey plot number in his report wrongly. As a matter of fact, no portion of foot land belongs to the defendant. Thus, the Amin's demarcation report is partly wrong, partly correct. However, it does not give the correct picture of the suit land. The plaintiff first state had filed in this case number 15 of 1988-1989 for correction of demand wrongly opened in the name of defendant in this case number 10 of 87-88 before the circle officer Majian. The matter was inquired into by the Kanchari circle inspector, and they reported that plot number 78 has a total area 27.25 acres, and the entire lands are in cultivating position of 21st acre. And secondly, Chhari Rajwar others, Ramdas Sarkar, Premi Devi Purja others, and no personal plot number 38 is in position to defend. So they prayed for suspending the demand for its correction contract. That thus it will be found that the land reform department had taken steps as stated above for correction the demand, and so the defendant cannot take any advantage of the same because such demand has been illegally and forcibly created. Thus, that I stated above, plaintiff are the occupancy area of the suit land, and the demand for the same is running in the Srista of the state of Bihar in their names in the present revenue survey. They have also been found in possession of suit land. The above order passed by the executive magistrate under section 145 CRPC has cast a cloud on their title and possession, so the plaintiff had been advised to seek declaration of their title and confirmation of possession alternative for recovery of possession in view of the order passed under section 145(7). This is the facts as created in the plaintiff, and the plaintiff has sought relief for declaration of title and alternatively for recovery of possession. And per contrary, the defendant opposed the suit by filing WS, and defendant has not rebutted the para 1 to 4 of the plaintiff. What has been stated in para 1 to 4 of the plaintiff? They have simply stated neither admitted the same nor denied the same. Their WS they have stated in para 8. Meaning thereby that regarding para what has been stated in para 1, 2, 3 and 4, which I have just referred to. They have stated that they are neither the relation between para 1 to 4 of the plaintiff are neither admitted nor denied. The plaintiff put district.
That's so you are supposed to prove.
Yes, the defendants further has contended. What is the claim of the defendant is not over plot 96 and 97. Their claim is not over plot 96 and 97. And the defendant has also pleaded in the plaintiff. I am just reading. And she has also claimed the land.
Which land?
Claimed the land different from the land as mentioned as suit land. So there is no claim of the defendant about suit land.
Let us.
All the points, all the facts that have been pleaded. Para 8.
para 11 से पढ़िए ना.
हाँ, para 11. That in para 7 of that plaintiffs have attempted to show the absurdity of the settlement with the defendant on the ground that settlement is alleged to have made in the year 1949, while she was only 14 years old on 3/5/87. And at the time of her deposition, it was disputed mistake. Therefore, she would have only been only 12 years old, and hence her claim of having taken settlement of coming in possession of suit land is baseless and false. But the plaintiff forget that settlement can be had by minor. एविडेंस इनके कंट्राडिक्टरी है, इनका डायरेक्ट नाम से सिद्ध है और ये पट्टा है. But the plaintiff forget that settlement can be had by minor through his or her guardian. In this case, Dhaneshwar Rajwar, the father of the defendant, had no male issue, but the daughter's mother. Dhaneshwar Rajwar loved the defendant most and obtained the settlement in her name for her benefit, even after her marriage, retained her with his son-in-law in his house to look after him. Hence, the settlement cannot be assailed because of the tender of the defendant at the time settlement. That the statement in para 6 of false and denied. No part of plot number 96 or part number 97 included in 3.50 acres total with the defendant described with the boundaries in the notice proceeding under section 144 I said. The defendant had no knowledge of any petition filed for them before the circuit officer Majhiam registered in demarcation case number 12 of 889, nor any measurement made by the wing. She was not a party in the measurement, as she was not made a party thereto, nor she was not to be present at the time of measurement, and therefore she is not bound by any report of the mean. More so, when the plaintiff themselves describe the means report to be partly wrong, partly correct. If the plaintiff alleged plot number 96 and 97 of the plaintiff's first state and part of plot number 28 of the plaintiff's second state are included within the boundaries of the land defendant in plot number 78, they are called upon to give the commissioner appointed by the court to prove the allegation. The defendant had again no knowledge alleged in para 9 of the plaintiff in this case number 15 of 88-89 before the CO Majhiam, as she was not made party in the proceedings. If there was any inquiry by Karmachari and the circuit inspector, it must have been done at her back.
ये तो सारी प्रोसीजरल चीजें हैं, पार्टी नहीं थे, बाइंडिंग नहीं थे.
लेकिन ये पार्टी थी एट हर इंस्टांस प्रोसीडिंग वाली सीट है, वो आया है, इनका एविडेंस भी है और इनके इंस्टांस में भी हुआ. और यहाँ तक कहते हैं बंदोबस्ती हमारे हम माइनर थे, हमारे फादर ने किया हमारे नाम से, जबकि बंदोबस्ती डीड जो सदा हुकुमनामा है वो कंट्रारी है, इनके नाम से डायरेक्ट, जब ये खुद माइनर करते हैं. जो इम्पोर्टेंट फैक्ट है जो हम दिखाना चाह रहे हैं कि इन्होंने जो जमीन को क्लेम किया है.
अब पैरा 15 पढ़िए ना.
पैरा 15
The father of the defendant.
पैरा 15 में पूरा डिस्क्रिप्शन दिया. The facts are as the father of defendant Dhaneshwar Rajwar had no son but daughter's son. Among the daughters, her father loved her most. He obtained the settlement of 3.50 acres of land plot number 28, measuring 27 acres, and all of village Gamdiria in her name for on ground of rent receipt followed by customary parwana dated 17/9 48 duly sold by भैया बता आपको the sole owner of the great Lantinia rent was paid to the landlord till the vesting of his intermediary interest in the state of Bihar in the year 1915. On her marriage, she lived with her father and served him till his death. On vesting of intermediary interest, the landlord sold her tenancy in respect of 3.50 acres of land of plot number 78 in plot number 78. A demand was not opened in her name by the state of Bihar. On the basis of return of the landlord, she filed a petition before the CM for opening demand in her name. Her petition was entertained in this case number 19 of 73 Singapore. On usual inquiry, the CEO ordered for opening of demand and realizing rent since the date of vesting and a correction slip duly signed by the CEO on 12/7/75 was issued to her. The KC did not comply with the order of the CEO. On the plea that the record of this case 19 of 73/74 was misplaced and nothing could be done till the record was found out. She then filed a petition before the SDO Garwa, which was entertained in this case 7 of 82/83. The SDO by his order dated 5/6/85 directed the CEO to open the demand in her name and realized it. But this order was also not heeded, and therefore she filed a petition for the AC Palam, which was entertained in this case 200 of 1985/86. On hearing the AC by his order dated 6/1/86 directed the CEO to carry out the order of the SDO and submit compliance report. Then and there, alone, the CEO started this case 10 of 87/88. He got an inquiry made by the CI, who reported that she was in possession of her 3.50 acres of land. On receipt of the report, the CI dated 12/1/88. He himself perusal all connected papers. Being satisfied with the perusal of all connected papers and report of the CI, the CEO, by his order dated 15/1/88, directed the KC to receive rent since the date of vesting. Since then, she rent for her 3.50 acres of land. That the defendant is in possession of the land settled with her, that is 3.50 acres in plot number 78. Since the time of her settlement on 17/9/48 openly, uninterruptedly, continuously, and reversely, hence she has perfected her title by reverse possession also. The of reverse possession. The plaintiffs and their father were very influential persons, and arbitrators, those persons.
बस बाकी तो फॉर्मल है कुछ नहीं.
हाँ बाकी फॉर्मल है. आगे.
So they are only claiming right in plot number for 78.
Para 16.
ये they are claiming right only in plot number 78, area 3.508.
On the basis of Sada Approval.
Settlement dated 17/9/48. And plus they are also claiming adverse possession.
Through her father.
Para number X.
Through her father.
That's right.
Being minor.
Okay. What were the issues?
Para 16. Para 16, the land of the defendant measuring situated so and so, that is different from the suit. That's why I am referring para 16. Not tagged, not fully tagged. In entirety.
This is the description of the property.
Property
Boundaries.
as claimed by the defendant.
That's it. The land of the defendant measuring 3.50 acre, read it please, is situated
on north-south of plot number 85 of Mandir.
on the south of plot number 85.
And east of plot number 97 of this query on the north and east are the lands of the ruler of Makruba. But this is not tallied with the suit.
The plaintiffs have no land within the boundary of the land of the defendant.
ये this is इनका केस है.
Yes.
जबकि plaintiff का suit मेरा ये है. Meaning thereby that both are different.
Meaning thereby, as per the plaintiff and the written statement, they are claiming different property.
Both are
Local
different.
inspection नहीं हुआ है.
Local inspection. Local inspection.
कोई prayer भी नहीं हुआ है.
आपके जिसका record तो पूरा order से नहीं देते हैं नहीं जो लग रहा है कि local inspection इसमें order से में आता है. अब कोर्ट ने क्या किया है, मतलब ट्रायल कोर्ट ने सभी रिलीफ को जो रिलीफ मेन रिलीफ है लीगल प्ली सबको दोनों पार्टी में नेगेट कर दिया. दोनों पार्टी में किसी का नहीं.
दोनों पार्टी में
किसी का नहीं. कोर्ट ने
तो आप प्लेंटिफ अपना प्रूव नहीं कर पाए होंगे, डिफेंडेंट भी अपना कुछ प्रूव नहीं कर पाया होगा.
हाँ मैंने जो बात है
ऐसा थोड़ी है कि कोर्ट को किसी न किसी के फेवर में फाइंडिंग देना ही होगा.
जो लिखा हुआ इंक्लूडिंग दी इश्यू एंड डिसाइड नेगेटिव टू द पार्टीज।
इशू बताइएगा क्या?
इश्यू है उन्होंने लर्नेड ट्रायल कोर्ट हैज क्लब्ड द इश्यू नंबर 8।
पहले इशू पढ़िए, इशू पढ़िए।
Is the suit I frame maintainable? Have the plaintiff any cause of action for the suit? Is the suit barred by estoppel recognition? Is the suit barred by law of limitation as well as adverse position? Is the suit bad for the multifariousness of cause of action? Is the suit further barred by non-granted necessary party? Has the suit been undervalued? Get proper court fee? Are the plaintiff occupancy lawyer of the occupancy lawyer in respect of the suit land, or the defendant is lawyer by virtue of alleged settlement in her favor by the then landlord, whether any part of plot number 96 and 97 amalgamated with the Sahib 3.50 acres of defendant in plot number 78, have the plaintiff entitled to any relief as claimed or any other relief, whether the defendant has valid right title interest over suit land, whether defendant has acquired the right title interest through settlement in the year 1948 over 3.50 acres land of suit plot number 78, which is the suit land. These are up to 13 issues.
So as per the plain and written statement, there is no common claim with respect to any portion of the property. आप कह रहे हैं कि आपका आइडेंटिटी अलग है, डिफेंडेंट अलग बोल रहे हैं कि इनका लोकेशन ही अलग,
हाँ वो तो है,
कोई ओवरलैपिंग ही नहीं।
थोड़ा बड़ा है कहीं
नहीं, ये तो नहीं।
थोड़ा कहीं एक प्लॉट के लिखा
डिमार्केशन का इशू था ना इसमें।
डिमार्केशन का इशू है और कोर्ट ने इनका सूट इसलिए भी डिसमिस किया है क्योंकि इनका ऑर्डर 7 रूल 12 इनका नहीं, इनका डिस्क्रिप्शन नहीं दिया, बाउंड्री नहीं दी।
बाउंड्री तो दिया है,
बाउंड्री खाता प्लॉट सब दिया,
खाली एक ठोका दिए हैं, बाकी का
नहीं सबको दिए।
सबका
कैसे बोल रहे हैं सबका?
नहीं सबका बाउंड्री में कहीं दिक्कत नहीं,
बाउंड्री में कहीं दिक्कत नहीं।
बाउंड्री खाता प्लॉट लिया सब।
भाई अगर वो बाउंड्री नहीं दिए रहते तो आप ये पैरा 16 में स्टेटमेंट कैसे देते? आपका ये केस ही नहीं है कि बाउंड्री इज नॉट क्लियर, दैट इज नॉट योर केस।
पार्टी वेंट ऑन ट्रायल।
एक बात बताइए, आपका रिटन स्टेटमेंट में ऐसा केस कहाँ है कि बाउंड्री इज नॉट क्लियर?
जी हम ये दिखाना चाह रहे हैं इनका जो मेन बाउंड्री जो दिया है,
ये
मेन बाउंड्री तो ये दिए हैं इसी का वहाँ का, और बाकी का जो बाउंड्री
शेड्यूल ए
जो मिला हुआ है
जिसका पार्ट है जो बोल रहे हैं दोनों का बाउंड्री डिफरेंट,
सब एक ही में मिला हुआ है जो मेरा उसी जगह बगल में है।
एक सेकंड, जो फाइंडिंग कोर्ट का आया है वो हम
पढ़ेंगे, हम देखेंगे, दिखाएंगे, हम ही दिखाएंगे।
तो आप लैंड का बाउंड्री दिखा रहे हैं और बाकी का बाउंड्री जो ये दे रहे हैं उससे मैच नहीं कर रहा है। दिस इज वन ऑफ द मेजर रीजंस। अब सूट का डिसमिसल का दोनों को इसी पॉइंट, और ये इशू स्पेसिफिक इशू अपील कोर्ट में डिफरेंट, ऑर्डर 7 रूल 3 के हिसाब से नहीं।
अच्छा एक बात बताइए, आप अपने बाउंड्री में किसी का नाम दे देंगे तो पोर्शन ऑफ प्लॉट नंबर लिखेंगे ना? ये बाउंड्री में नाम देने से क्या होगा?
बाउंड्री में नाम, चूंकि बाउंड्री में नाम,
बाउंड्री में आप लिखेंगे ना एडजॉइनिंग प्लॉट पार्ट ऑफ प्लॉट नंबर सच एंड सच या पार्ट ऑफ खाता नंबर सच एंड सच, वो तो कुछ नहीं, खाली नाम लिखा हुआ है, इसका क्या रेलेवेंस है?
the order 7 rule 3 applies only
नहीं आप एक चीज पहले तो आपका कॉमन सेंस लगाइए। जब तक आप उसमें कुछ लिखेंगे नहीं एंड एडमिटेडली जो भी प्रॉपर्टी है वो पूरा प्रॉपर्टी नहीं है, और पूरा प्रॉपर्टी है भी तो दाएं बाएं कौन सा प्लॉट नंबर है, कौन सा खाता नंबर है, ये है ही नहीं। ये कैसे इससे पता चलेगा? इससे क्या बाउंड्री आप पता कर सकते हैं, बताइए? The description of property is actually not correct.
But parties went on trial.
Parties went on trial. There is no.
This was not the dispute raised.
That is the dispute raised.
No,
there is the concurrent finding of two courts.
ठीक कंप्लेंट फाइल ऑफिसर
भाई
लिखा है।
कोर्ट आपको डिक्री
There-
करेगा, कोर्ट आपको डिक्री करेगा तो बाउंड्री नहीं देखेगा।
No issue was neither in the written statement nor issue was framed that the suit is barred under Order 7 Rule 3. This was not pleaded by the defendant, and in absence of written statement, this is my submission. In absence of written statement, the first appellate court and as well as trial court has travelled beyond the pleading. In absence of any pleading, this is my submission. This is the substantial question, main substantial question of law. That the grounds for non-suit is that the court has made out a third case of its own. Because the defendant has claimed separate land, plaintiff has claimed separate land. So what was the occasion for the court holding that the suit is barred under Order 7 Rule 3 of the CPC? अगर ऐसा होता तो डिक्री एक्सिक्यूटेबल नहीं होता। अगर मान लीजिए सपोज फॉर ए मोमेंट दो आई एम नॉट एक्सेप्टिंग दिस, लेकिन इनका ऑर्डर 7 Rule 3 का कहीं दिखा नहीं कि कहीं इन्होंने एक शब्द भी लिखा है।
कानून को फिट करना जरूरी नहीं, मटेरियल फैक्ट्स आर टू बी
ऐसे ही सब
आप CPC से दिखा सकते
नहीं, हम उस पर नहीं हम उस पर जजमेंट देंगे सुप्रीम कोर्ट का। अभी हम दे रहे हैं तो हाँ नहीं ठीक है। अब व्हाट द फाइंडिंग्स ऑफ द लर्नेड ट्रायल,
Just a moment.
व्हाट लर्नेड फर्स्ट
Just a moment.
लर्नेड ट्रायल कोर्ट ठीक के रिमांड रहता है, कहीं डिसाइडेड नहीं कुछ हुआ है। पार्टी अलग अलग का तो सूट शुड हैव बीन डिक्रीड। आप थोड़े इसको पर्टिकुलर करें।
चलिए जरा हम लोग को जजमेंट दिखाइए।
ट्रायल कोर्ट ट्रायल court judgment finding starts from the running page of the brief 48 internal page 20.
Yes.
On meticulous scrutiny of the submissions of the parties and materials.
Internal page 20, just a moment. हाँ बताइए।
On meticulous scrutiny. On meticulous scrutiny of the submissions of the party and also the materials of the court with the evidence of both the party. It appears that both the party have tried to prove their case with the production of evidence of both oral and written. It also found that the evidence of the party that suit brought for 78 in the legal about more than 27 acres. It has also found the evidence of the party that part portion of the land within production 78 of both the parties found in the evidence. Both the parties found in evidence, meaning thereby the plaintiff was also found in evidence, found in possession. plaintiff had agitated the order of revenue court in which the possession of the defendant was found in this case number 67536 under section 145 5 USC is also the order of criminal revision number 1/7 of the year 1989. 5 is exhibit C for documents so that in proceeding under section 145 7 C for the party appeared before the Supreme Court and they have properly pleaded evidence when it was found there is some overwriting in clause 96. The document produced on behalf of the plaintiff for Khata number so and so and out of several plots given in the state Khata and the plots were found in the portion of 3.50 acres land in Khata number 1/19/28, 78/260, 78/267, 78/269. Were found very much different from the suit land. In that draft record of right, nor any plot of 350 acres and was mentioned also in the present business. But it also appears that defendants have no documents, other documents to show that land was coming since this land and rent was issued by the Bihar government in the year 87 and 88, and on the basis of this case, 19 of 73, 74, rent was assessed in the name of defendant.
ये वाला जो ये ऑब्जर्वेशन है ना, this is matching with your additional evidence, right? This is exactly matching with your additional evidence.
Since rent receipt, I also have the rent receipt.
You see, the document which you are relying upon इतना heavily additional evidence फाइल कर, उससे आपका कुछ फायदा नहीं होने वाला, उससे नुकसान ही होने वाला है.
But
you are not going to be benefited by that.
But the rent receipt and register too also reveals that a rent was assessed. And the finding of
further
that it also appears that the defendants have the documents to show the land was coming since rent was issued by the government in the year 1988, and on the basis of this case 73-74, and rent was assessed in the name of the defendant. This is also beyond 20 pleading का 73-74 से नहीं हुआ है, तो बाद में हुआ, बहुत बाद में. Further, in the document of return submitted by the Jamindar, the name of the defendant appears bona fide, and then on the basis of the above, also on going through the rural statement of the witness, and also the possession of the land in question are found in favor of the defendant. And as such, the Supreme Court has passed the order in favor of the defendant, and the criminal revision number gives 6 by 6. The session that also found the settlement of both the parties on portion of plot number 78, and the land of 3.50 acres in plot number 78 was settled by this landlord to the defendant. Before vesting rent, see a free rent is till the vesting rent. After vesting of rent, he is paying rent to the state government, but there was no settlement of 350 acres land found in the state order in the name of the plaintiff petitioner. Rather, the boundary given by the petitioner plaintiff was something different on the basis of the contention submitted. The London sensation that found in their order that there was no such land having area and same boundary for the proper appreciation location of the land question. Further, in your opinion, the exact location of the land question, the agreed parties should have trade the lower court for sport inspection by appointment of survey knowing a commissioner, but it was not done by the agreed party and such prayer of the petitioner. Plaintiff had been reviewed in the order of petitioner that now on 27/11/90. It also appears that the order passed in proceeding under section 145 say application for confirmation of petitioner of land question, and further to confirm the state order in the criminal revision is showing complete change. So far the order passed in earlier in the proceeding under section 144 CRPC in case number 290 of 86. So far the statement of plaintiff for the alleged demarcation case number 12/88/89 defendant have challenged the same as per their statement that they have no knowledge for any demarcation case. While the order sheet dated 12/8/88 produced on behalf of plaintiff to show the said case was for the defendant was here done, mentioned there is that measurement of land was earlier done at the instance of the petition. As the plaintiff have submitted their proof circular of the job, however, there is no detailed document available for the said demarcation case to see the exact and the clear-cut picture for the land question. Whether it was included in the state demarcation case or not. Further, given 6 by D, the order sheet of this case number 58/89 or Andres also shows the report of Halka Kanchari coming through CI to the circular. But this also is not a complete document to show the subject matter of the food land, whether included in the proceeding or not. Nor the plaintiffs have submitted details through thereof in the pleading. The document showing registration for the Khata number 25/7, 1/90 having different plots. Also the picture of writing or plot was 28 to 69 area 0.96 acre. Further, there is no clear-cut explanation for that on behalf of the plaintiff to show that exact position of the suit. It also appears from the documents produced on behalf of the defendant to show that demand for plot was 28, Khata number 1 area 3.50 acres had been opened and accordingly the rent was assessed in the name of the defendant. And the defendant has produced the rent receipt in DS3 to show her direct physical position since opening of demand about the suit land. Other defendants have also produced a direct receipt to show receipt to show her physical and distinct portion of the suit land. So far the statement of defendant for the settlement of the land since the lifetime of the expander, we have in this context on behalf of the defendant on Wasti Pata and D and Jamindai Rent C have been filed on behalf for the other documents with regard to the opening of demand for the defendant in Exhibit F and Exhibit I. The land was suing in the name of Punjab Divine Wife of Monroe's Land Compensation Case 353-54. The incident of hearing Pratapdev, another state, to sue the return of final dictionary, suing the defendant and the secretary of dictionary. And in this way, the defendants have tried to extend the pleading for the land in question coming in their physical exclusive position since the period of dictionary. Further, in the overall document, the defendant has also submitted that father allowed her settlement in the land in her name in her minority. And in this way, the defendant had discarded the statement of plaintiff against the settlement in her name. The other documents produced on behalf of the plaintiff, which here by 3 by 4 are the same document the plaintiff have stated in the suit I degree 6 and 6 by 3. In this way, the defendants have also tried to say with regard to the pleading their suit land in inherent physical position in right at the settlement made by the settlement, which had been duly confirmed by the government and all the revenue records in her favor, where the plaintiffs have denied the documents of the defendant. So far, the document produced on behalf of the plaintiff with regard to information submitted by the record is concerned. The revenue records produced on behalf of the defendant going to show that the land of the defendant in their land is the same Jharkhand plot, which had also been informed in the statement of the witnesses of both the parties. Therefore, this document is not showing the complete statement of the plaintiff. And so far, property is concerned. However, both the parties have also produced rent receipt, that is rent receipt of the plaintiff in Exhibit 2C, where the government rent receipt produced on behalf of the defendant in Exhibit AC. And it is also found that land of both the parties within the same vicinity. And the witnesses have also supported the statement. Further, it is clearly depicted in the evidence of the party that plot number 28 is heavy bigger, so the plaintiff's case appears to be not in complete form to show the exact physical position of the land question in favor of the plaintiff. Whereas the area of boundary submitted on behalf of the plaintiff appears to be very much confusing and doubtful. On the other hand, it is also not said that without measurement of physical position to locate the specific boundary, the land question goes in favor of the defendant. Though it cannot be denied, the land of plaintiff and defendant appears as per evidence in plot number 78. So the evidence also shows that plaintiff have not explained clear cut for the suit land, and this context which say record of right, Kata number 1 produced on behalf of plaintiff also shows in plot number 28 area 3.50 land of Gambia in village Gambia. Therefore, from the statement of plaintiff itself, there is very much contradiction for the suit property as submitted in the pleadings of the plaintiff. Further, there is no case of plaintiff in the present facts and circumstances material below. On the other hand, though there is land of the defense of the suit property, but there must be specific demarcation of the land to ascertain the exact portion of out of big plot number 28, which has also been affirmed in the statement of the defendant, as well as without clear cut demarcation of the boundary of the land question. Neither of the party can claim the suit property for him. Accordingly, this is the answer and decided in negative.
क्या किया, क्या गलत है इसमें? बताइए, कोर्ट को पता नहीं चल रहा है, आप हमको समझा दीजिए कि बिना प्लॉट नंबर के कोई बाउंड्री हो सकती।
प्लॉट खाता दिया हुआ है,
प्लॉट खाता पूरा नहीं है ना आपका, एडमिटेडली पूरा नहीं है आपका। इज इट योर केस दैट द एंटायर प्लॉट नंबर इज योर्स? और उसका प्लॉट के में बाउंड्री क्या है आपके प्रॉपर्टी में? बाउंड्री में आप लिख दिए 4 आदमी का नाम।
बाउंड्री में हमने
So is it a proper way of description of property?
बाउंड्री
If the court is not in a position to understand, you see, in the trial court says that a pleader commissioner was required to be appointed. आपने वो स्टेप ही नहीं लिया, appellate court में भी स्टेप नहीं लिया।
तो प्लीडर कमिश्नर का अगर रिपोर्ट की आवश्यकता थी, कोर्ट तो अपने से भी कर सकता है।
अपने से तो हम भी कर सकते हैं।
ऐसा तो नहीं है कि नहीं उनका हैंड।
क्यों आप लोग विद्वान किस लिए?
हाँ नहीं, ठीक है, विद्वान या जो नहीं है, लेकिन
नहीं है तो हम लोग क्या करें?
उसमें ऑर्डर 26
देखिए, I'll tell you one.
हाँ,
On account of vagueness of the description of property, both the parties have been non-suited. Correct? Your remedies are still open. आप अपना प्रॉपर बाउंड्री के साथ फ्रेश सूट फाइल कर दीजिए। किस लिए लड़ रहे हैं आप इस केस में? They can still file it. Anybody can still file it. What's the big deal about it? Well, you have been non-suited because the proper boundary has not been given. Even their description of property is not correct. वो भी अपना बहुत ही वेग नॉर्थ ईस्ट साउथ पता नहीं क्या दिए आपका बाउंड्री। तो ऐसा तो नहीं है कि उनके फेवर में आपका जमीन लिख दी जज साहब। तो क्या है इसमें बताइए? You are absolutely unable to describe the property.
but
can't be like this.
both
और दूसरी बात जिसके बारे में बोले हैं वो रजवार वहाँ पर है, लेफ्ट में वो है, राइट में वो है, उसका कोई डीड कुछ प्रोड्यूस किया है? कुछ नहीं। कैसे होगा डिसाइड? वो आके गवाही दिया है कि हम इनके बाउंड्री पर हैं। ये डिस्क्रिप्शन ऑफ प्रॉपर्टी सही नहीं है तो कोर्ट विल कैसे, हाउ विल द कोर्ट डिसाइड? जैसा वेग प्लेंट है वैसा ही वेग जजमेंट है। एग्जैक्टली।
Commission to make local investigation.
You see?
Gives a local investigation.
I'll tell you. Yes.
To be refused. So the court has not taken.
हाँ तो हम इसको थोड़ा वापस भेज देंगे क्योंकि इसमें आपको बहुत अमेंड करना पड़ेगा। जब वहाँ पे लोकल इंस्पेक्शन हुआ ही नहीं, प्लीडर कमिश्नर अपॉइंट हुआ ही नहीं, बाउंड्री इज नॉट क्लियर, हाउ आर यू प्रेजुडिस्ड? इसको लड़ रहे हैं इतना दिन से, अभी तक तो एक फ्रेश सूट फाइल करके आपका हो जाता कहानी खत्म।
अब दोनों पार्टी अलग-अलग कहते हैं, then what about the remaining?
तो क्या डिसाइड कर देते, क्या चीज आपके फेवर में डिसाइड कर देते, आप ही बताइए।
When the defendant is not
See the plaintiff is
बोल ही नहीं सकते, इसलिए नहीं बोल सकते।
when the defendant
अगर इनका लैंड हमारे लैंड से अलग है, तो इनको क्या जरूरत है हमको पार्टी बना के इतना दिन लड़ाने का? हमको तो कॉस्ट मिल रहा है।
आज चुकी आपने 145 प्रोसीडिंग हम इनिशिएट किया।
इनिशिएट किया ना, जब आप 144, 145 आपस में लड़ रहे हैं तो आइडेंटिटी ऑफ प्रॉपर्टी ओवरलैपिंग ये कुछ तो होगा ना।
The learned session judge also observed regarding appointment of commission.
Yes, वहाँ पे भी नहीं हुआ।
And the
वहाँ पे भी नहीं हुआ।
trial court
has also observed कि नहीं हुआ।
The illegality, the trial court has recorded the finding on the basis of the findings of in a proceeding under section 145, not independent finding.
I'll tell you one thing.
Independent finding.
एक second. The court has not recorded finding in favor of anyone. ना आपका टाइटल डिक्लेयर किया है ना उनका टाइटल डिक्लेयर किया, बोले डिस्क्रिप्शन ऑफ प्रॉपर्टी ही प्रॉपर नहीं है। द कोर्ट वाज नॉट एबल टू फाइंड आउट। जबरदस्ती किसी को दे देंगे क्या? मान लीजिए एक्स पार्टी भी होता तो आपको टाइटल डिक्लेयर कर देते क्या विदाउट प्रॉपर बाउंड्रीज? इफ द कोर्ट इज नॉट सैटिस्फाइड, कोर्ट विल नॉट डिक्री द सूट। लिख रहे प्लीडर कमिश्नर बिना अपॉइंट हुए नहीं हो सकता है, तो इसमें आपको क्या नुकसान है? इसका तो कोई मतलब ही नहीं है। अब ये इतना सब्सटेंशियल क्वेश्चन ऑफ लॉ बनवा दिए हैं, बताइए।
सब्सटेंशियल क्वेश्चन ऑफ लॉ तो जो बना है सो मटेरियल,
क्या मटेरियल? कुछ नहीं है। कौन सा मटेरियल पॉइंट है? इस तरह से सब्सटेंशियल क्वेश्चन ऑफ लॉ बनवाते हैं आप लोग, बताइए तो। Whether the concurrent finding of both the courts below suffer from perversity due to non-consideration of issues involved in this case on the basis of evidence oral and documentary adduced by the parties? ये कौन सा सब्सटेंशियल क्वेश्चन ऑफ लॉ?
Though the plaintiff has to, that is such a principle. But
अभी ये बहस करेंगे कि ये कोई सब्सटेंशियल क्वेश्चन ऑफ लॉ ही नहीं। पहला बहस यही करेंगे वो, ये क्या, ये बताइए आप हमको।
Substantial question of law are trained in presence like that.
Presence से क्या हो गया?
He cannot. The
लोग को तो हुजूर पोटेंशियल क्वेश्चन ऑफ लॉ के समय हुजूर लोग सुनते कहाँ?
अरे ये क्या?
ऐसा कहाँ से?
हमको करने दीजिए तब सुनेगा।
ऐसा कहाँ?
ऐसा ही कैसे कर सकते?
नहीं ऐसा कहाँ आप बोल रहे हैं?
There is no provision under law to hear the respondent at the stage, and still they can, and I am unable to understand this substantial question of law.
लेकिन क्वेश्चन ऑफ लॉ जो सब्सटेंशियल क्वेश्चन ऑफ लॉ उसको थोड़ा
एक एक करके जरा पढ़िए ना, हमको बताइए कौन सा।
आप अपीलेट कोर्ट का फाइंडिंग देखिए, हम उसके बाद अपीलेट कोर्ट का फाइंडिंग देखिए।
इसीलिए हम आधा घंटा सुन के सब्सटेंशियल क्वेश्चन ऑफ लॉ बना।
नहीं हाँ ठीक है बताइए।
क्योंकि हम ऐसा बनाएंगे तो हमको जब डिसाइड करना होगा तो आई विल गेट लॉस्ट, आई विल नॉट बी एबल टू डिसाइड।
But so far the appointment of commissioner that the hand of the court is not fit. Court so moto can appoint.
वही लिखा देते हैं, कोर्ट शुड आपका यही सबमिशन लिखा देते हैं
मतलब
और यही बोल के हम डिसमिस कर देते हैं दैट
डील्स रिक्वेस्ट अगर ऐसा है ना ये हम इस पॉइंट पर
कोर्ट विल डू एवरीथिंग सो मोटो एंड यू विल नॉट डू एनीथिंग।
नहीं it is also in comment it is also in comment.
कोर्ट को लर्नेड किसने बोला है? कोई नहीं बोलता, ओनली द एडवोकेट्स आर लर्नेड। कोर्ट्स आर नॉट सपोज्ड टू बी लर्नेड।
My contention is that
अपीलेट कोर्ट दिखाइए।
appellate court whether the suit letter is specified in the plan and evidence of the plan and the evidence of the plaintiff's appellants. Whether the plaintiff appellants have got right title over the suit. In order to come to the conclusion.
कहाँ है point for determination?
23 running page brief 23.
Father 7.
23.
In order to come to the conclusion, as the suit land are specified in the plaint, and the evidence of the plaintiff, the court would like to observe here in the case of civil nature of documentary evidences are of prime concern, if available in comparison with oral. It is also set up in so order that the party who has come up with the case has to prove the same. It cannot take benefit of lesser on the part of the only party in a case of dispute of civil nature. The pleadings of the plaintiff are going to show in para 1 of the plaintiff plaintiffs have claimed about more than 3 acres, 10 होना चाहिए, and more plot plus 28, more than 3 acres in plot plus 73, as well as about 1 acre in plot plus 96. Therefore, exact area of the said lands have not been calculated. PW4 Suresh Rajwar, plaintiff claim number 3 in para number 8 of 2011 stated that he could not say how much land they have in the respective khata and ये finding erroneous है. उसमें दूसरा PW10
एक सेकंड रुक जाइए, वेरीफाई करेंगे ऐसे थोड़ी दिखाइए, एविडेंस दिखाइए।
देख लिया तो लास्टली हम दिखाते हैं नहीं वर्ड हम दिखाते हैं, हम तो अपने दिखाएंगे पढ़ान
PW7 PW4
ये खाता है डिस्प्यूट में नहीं बोला तो कोई नहीं बता सकता है कितनी जमीन है ऐसे खाता है डिस्प्यूट में गांव में बोला हम देख लेते
क्रॉस का पैरा 8 राइट।
हां PW4
पढ़िए।
मेरे पिता को गांव में कितनी जमीन है, मेरे नाम पर कितनी जमीन है नहीं कर सकता, किस किस प्लॉट में हम लोग की जमीन है नहीं कर सकता। वो जमीन पिता के समय से चली आ रही है, कब से ऐसा ही नहीं बता सकता। पिता की जमीन के अलावा अन्य अपनी जमीनों में किसी जमीन की चौधरी नहीं कर सकता।
कुछ नहीं पता, ना चौधरी बता सकते ना कुछ बता।
But in dispute, the learned appellate court has recorded that in dispute, suit land.
नेचुरली सूट लैंड के बारे में ना बात कर रहे हैं।
उनको तो बहुत जमीन अधिक है, 16 एकड़ 78 डिसमिल का जमीन का संस्था दिया हुआ प्लेंटिफ ने दिया खटा सभी प्लॉट में।
एक सेकंड, मेरे ये कौन है, ये PW4 कौन है, प्लेंटिफ है?
हां PW4 हां सब्स्टिट्यूटेड प्लेंटिफ है,
सब्स्टिट्यूटेड प्लेंटिफ है ना। मेरे पिता को गांव में कितनी जमीन है एवं मेरे नाम कुल कितनी जमीन है नहीं कह सकते। इसका क्या मतलब है? अपना जमीन भी तो बोल रहे हैं।
सर्टेनली अगर पूछा है अब तो मैं अपना जमीन नहीं बता सकता हूं कि कितनी मेरी नेटिव विलेज में जमीन है।
आप बहुत
बड़े नहीं हैं क्योंकि कंसर्न बहुत नहीं रहती है।
अरे भैया, बड़े लोगों को नहीं पता होता है उनके घर में कहाँ सोने जवाहरात छुपे हुए हैं। हो सकता है कभी आपको
अब एग्जैक्ट एरिया से बताना रस्टिक विलेज कैसे है,
हो सकता है कभी आपको किसी कोने में कुछ रुपया पैसा जेवर मिल जाए क्योंकि आपको पता नहीं
कभी नहीं रहेगी। एग्जैक्ट मेजरमेंट से नहीं बता पाएगा, एग्जैक्ट मेजरमेंट से कैसे बताएगा?
बाउंड्री में नहीं पता, चौहद्दी नहीं पता।
का रस्टिक विलेजर है ये तो,
अब रस्टिक विलेजर ये झारखंड का अच्छा ये
झारखंड का है
एक शब्द यूज हो गया है रस्टिक विलेजर।
हां तो इनका
एक बात आपको बता दें, ठीक है, थोड़ा एक्सपीरियंस हमको भी है गांव का, हमसे ज्यादा वो लोग समझते हैं कि उनका आपस में झगड़ा क्या है। इतना आपको बता दें,
झगड़ा समझते हैं कि खाता
झगड़ा गांव में ऐसे भी लोग हैं जो अनपढ़ हैं लेकिन रोज कचहरी जाते हैं एवरी डे, क्योंकि उनके पास कुछ ना कुछ लिटिगेशन रहता ही है। अब वो लोग ऐसे हैं कि आपको बैठा के पढ़ा देंगे।
वो तो कुछ सभी नहीं
ऐसे हैं, बहुत लोग हैं। और ये जो है ना, ये जो लिटिगेशन जो है ना, इनहेरिट भी करते हैं लोग।
हाँ वो तो है, बहुत
जिनके घरों में दिन रात जमीन का बात होता है ना, उनके घर में 10 साल के बच्चे भी आपसे ज्यादा जानते हैं।
बहुत क्रोनिक लिटिगेशन है, होता है।
तो इतना बता रहे हैं।
बहुत
एंड आई हैड अ लिटिगेंट हु वाज ब्लाइंड, अनपढ़, लेकिन वो जो हमको पढ़ा के गए ना, कोई नहीं पढ़ा सका। इसीलिए ये अनपढ़ और रस्टी के सब कहानी बंद कर दीजिए।
हाँ, लेकिन डिस्प्यूट में जो लिखा हुआ है वो हम बोल रहे हैं
बिल्कुल सही लिखा हुआ है, कुछ नहीं है इसमें।
फर्दर
एंड आई एम रियली टेलिंग यू विथ माय ओन एक्सपीरियंस, एक अनपढ़ ब्लाइंड आदमी ने जो हमको लॉ सिखाया है ना, वो तो चले गए, हमको बाद में पता चला सुप्रीम कोर्ट से जीत गए।
हाँ होता है, हम उस पर नहीं बोल रहे हैं, लेकिन हाँ।
इसीलिए ये पर मत, लिटिगेंट को एग्जैक्टली पता हो,
एग्जैक्ट बताना सभी के लिए difficult।
बाउंड्री नहीं पता है, बोलते बाउंड्री नहीं पता है हमको।
अब किसी
What
को
else?
मान लीजिए अगर मान 5 एकड़ जमीन है, बात थोड़े मोमेंट बताना है, 5 एकड़ है तो सबका बताना डिफिकल्ट हो जाता है किसी के। तो हम अपना हम खुद नेटिव विलेज का नहीं बता सकते, हम दूसरे को नहीं बता सकते हम क्या चीज है।
आपको 2-4 एकड़ 10 एकड़ जमीन चला जाए तो आपको फर्क
नहीं वैसा नहीं है, लेकिन नहीं अभी भी नहीं बता सकते अपने अब जहाँ के हैं हम, अगर ये बता देंगे तो हम नहीं, लेकिन हम ऐसे ही बोल रहे हैं इस बात के लिए।
ठीक है,
आगे
केस में बता दो।
केस कचहरी देखो।
केस में करना तो वो तो वकील साहब सिखा के जाएंगे, वकील साहब सिखा के जाएंगे तो बोल देंगे।
वकील साहब को बता के नहीं जाते।
हो गया, आगे बढ़िए, PW4 का कहानी सुनिए।
PW10 Ramdas plenty of land number 1 have stated in the examination sheet that about 15 to 16 acres land in different color as they have acquired, and thus they have not also stated about the exact area of the suited. Apart from there are 3 schedules of land in plan, namely A, B, C. Out of the schedule A, the suit which includes schedule B and C, the suit land under schedule A which are specified. This is the finding, which are specified.
Suit land which are specified with specific boundary but schedule B and C land are included under schedule A having different boundaries.
Certainly, that can be certainly because schedule B and schedule C and both comprises of schedule A. But the different boundary, certainly different boundary will be there. Therefore, this court comes to the conclusion the suit land are thick and not specified in boundary and are thick, and area as required under the penalty provision of CPC. Under order 7 rules, these are the pleadings of the plaintiff to appear defective and it is accordingly it is answered. There are no pleading of the defendant regarding under order 7.
कुछ नहीं है आपके केस में, आप जो है ना, जो शेड्यूल A, B, C है, बाउंड्री बना के दिखाइए। बोल रहे हैं ना कि बहुत क्लियर है, डेमोन्स्ट्रेट। चलिए डेमोन्स्ट्रेट करिए।
लीडर कमिश्नर की मुझे पॉइंट बता ना,
तो भी नहीं कर पाता, वो नहीं समझ पाता।
वो तो हमें के साथ हमें के साथ उसमें साइंटिफिक
अपार्ट फ्रॉम दिस सेकंड अपील, आपके पास फ्रेश सूट फाइल करने में कोई परेशानी नहीं है। यू कैन ऑलवेज फाइल योर यू आर इन पोजेशन,
यस
यू आर इन पोजेशन।
Yes.
फिर किस लिए लड़ रहे? क्या चीज का लड़ाई कर रहे हैं आप?
145 में हमारे पोजीशन
आप अपने पोजीशन, भाई कोई बात नहीं, आप पोजीशन में है ना,
हम जमीन उस
हमने
आपको लिटिगेंट से इंटीमेशन है ना?
हां
क्या
लिटिगेशन
position है?
लिटिगेशन कैसे है?
इनको इंटीमेशन है कि ये पोजीशन में है, दोनों अपना अपना जमीन पोजीशन में, तो किस लिए लड़ रहे हैं आप लोग?
तो इसको हुजूर मीडिएशन
नहीं, अब क्या मीडिएशन हो गया खत्म?
लेना चाहिए इनको हुजूर।
अगर उस वक्त कुछ में तो पड़ेगा
आप शूट का
दोनों का अगर सेटलमेंट हो जाता है तो अच्छी बात है।
क्या सेटलमेंट? कोई सेटलमेंट नहीं हो सकता।
आगे फर्दर
सेटल, यू हैव ऑलरेडी सेटल्ड योर डिस्प्यूट।
अगर फर्दर अगर ये है
कुछ
लेकिन हमारे जमीन को क्लेम कर रहे हैं तब तो
हम
इनका
क्लेम कर रहे हैं, ये तो आपने उसमें लिख रहे हैं कि इनका जमीन और आपका जमीन का आइडेंटिटी अलग है, लिख देंगे वो भी हम। आपका प्लेन रिटन स्टेटमेंट का सब कहानी लिख देंगे। वो बोल रहे हैं उनका आइडेंटिटी अलग है, आपका आइडेंटिटी अलग है, तो काहे के लिए लड़ रहे हैं? तो जबरदस्ती वाला लड़ाई है ना, कोर्ट का टाइम ऐसे बर्बाद करने के लिए नहीं।
ओवरलैपिंग वाला पोर्शन में हमको बेमतलब को परेशान कर रहे हैं, सच्चाई है।
वो मतलब ही नहीं है, जिनको दर्द है वो हॉस्पिटल जाएंगे, यानी कि अपना सूट फाइल करेंगे।
फर्दर जो फाइंडिंग है
कुछ अब ये सूट का प्रॉपर्टी क्लियर नहीं है तो ये सब्सटेंशियल क्वेश्चन ऑफ लॉ कैसे अराइज करता है, जरा हमको बताओ। अब बस आ जाइए इसमें, आप बहस करेंगे ना, ये अराइज नहीं करता है।
बिल्कुल यही तो पॉइंट
करिए बहस करिए, जवाब
पॉइंट है।
अब हम इसी पर
चलिए। फर्स्ट सब्सटेंशियल क्वेश्चन ऑफ लॉ बताइए कैसे अराइज करता है?
सबसे पहले तो हम इसमें एकदम कोर्ट ने प्रॉपर इश्यूज फ्रेम किया। लेट मी शो यू
डिफेंडेंट का इशू
छोड़ दीजिए ना, पहले बताइए कि पहला सब्सटेंशियल क्वेश्चन ऑफ लॉ का हम क्या मायने मतलब निकालें और वेदर इट इज अ सब्सटेंशियल क्वेश्चन ऑफ लॉ।
और बहस करना चाहते हैं।
हो गया ना इनका बहस, अभी और बाकी है क्या?
तो क्वेश्चन ऑफ लॉ जो है
पढ़िए।
There are the concurrent finding of both the court suffers from controversy due to non-consideration of the issue involved in this case, and on the basis of evidences, oral and documentary reduced by the parties.
इशू क्या होना चाहिए था अकॉर्डिंग टू?
Issues what order 14 से material proposition of law
आप ही बताइए ना इशू
filed by one party and denied by the other. The claim of the defendant is not related to plot number 96, 97. And my claim is that plot number 78, 96, 97, what I am claiming, that is in one compact plot. And the claim of the defendant is not on it.
So according to you, just a moment. Defendant has not claimed
plot number 96 and 97.
Over
Plot number 96
plot number 96
and 97.
and 97. Their claim is only on
Plot number 78. Only with respect to plot number 78.
हम थोड़ा इशू नंबर 9 देख लिया जाए. ट्राई करो.
हाँ ठीक है, उसी पर हमारा उसको there is no finding on it.
only on plot number
78.
78. There is no finding for a reason because the description is not proper.
But the issue has claimed whether any part of plot number 96, 97 amalgamated with 3 acres. This was the issue framed. But no discussion, no finding on it.
The court was unable to give any finding because the description of the property, the boundaries of the property are not clear. कहाँ से finding दे देंगे?
No pleader commissioner report.
No pleader commissioner report. That is why the court has not been able to give any finding on
Parties
this.
went on trial, led evidence.
अब
Both parties have used
विद्वान अधिवक्ताओं के बारे में हम ज़्यादा कुछ नहीं बोलना चाहते.
And there is no discussion of oral evidence by the first.
क्या oral evidence discuss?
First of all,
फोर का पढ़ रहे थे.
Appellate court का ही तो पढ़ रहे थे.
अभी तो पढ़ रहे थे.
Plaintiff of the evidence में बोलता है उनका boundary नहीं पता,
तो बात
area नहीं पता.
ज़्यादा पढ़ने से और गड़बड़.
और फर्दर जो टाइटल के बारे में उन्होंने दिया है,
देखिए और बताइए, ये तो पहला वाला हो गया कि इशू जो है आपका कहना ये है कि
सभी इशू को इंडिपेंडेंट अलग सेपरेटली नॉट डिसाइडेड.
इंडिपेंडेंटली नॉट डिसाइडेड.
Not
तो
decided.
इशू तो सही बनाया है ना.
To
some extent.
डिफेंडेंट का इशू क्यों बनाते हैं? डिफेंडेंट का इशू तो बनने का
इशू तो बनेगा, ये क्यों नहीं बनेगा? डिपेंडेंट अगर क्लेम करेगा तो बनेगा.
क्लेम नहीं किया उसने का ना कोई अपना क्लेम किया तो डिफेंडेंट सिर्फ अगर इशू ही बना भी ताकि लिमिटेड है कि उस पर कोई फाइंडिंग नहीं.
नहीं अभी
अगर ये फाइंडिंग दे दिया जाता कि एडवोकेट कमीशन रिक्वायर्ड है कर दिया जाता तो मैटर उठा भी लगा.
सुप्रीम कोर्ट पे जाएगी.
इससे नहीं होगा. जिस तरह का बाउंड्री आपका दिया हुआ है ना, हम कर देते. एक केस में हम किए हैं, हमको पता है.
हां एक कोई केस है.
हम एक केस में किए हैं प्लीडर कमिश्नर अपॉइंट, यहीं से सेकंड अपील में किए.
हां एक केस.
लेकिन यहाँ पर ऐसा बाउंड्री आपका है, इससे कोई फायदा नहीं और आपको इस जजमेंट से कोई नुकसान नहीं है. कितना दिन जाना चाहते हैं आप?
जजमेंट से नुकसान है, नुकसान स्पॉट पर हो गई है ना, नुकसान स्पॉट पर.
तो आप सूट फाइल कर दीजिए ना. स्पॉट पे नुकसान हो रहा है तो आप सूट फाइल कर दीजिए. वो पुराना कपड़ा को सिल के कितना बार पहनिएगा?
गरीब आदमी
नहीं, आप समझ रहे हैं? That is, it is now, it has gone. This litigation has gone beyond repair.
स्टिचिंग. नॉट स्टिचिंग.
कुछ फाइंडिंग जो है सो इन
नहीं हो
प्लीडिंग है, बस इन सेंस ऑफ प्लीडिंग और 703 का प्लीडिंग नहीं था. और
प्लीडिंग नहीं था तो भी कोर्ट नहीं देखेगा. कोर्ट दो चीज तो जरूर देखेगा कि हम डिग्री कर सकते हैं कि नहीं कर सकते हैं. कैसा हवा में डिग्री कर, लिमिटेशन और ये दो चीज तो देखना है. कुछ है नहीं इसमें.
इसका सेकंड भी उसमें कर दिया.
नहीं सेकंड तो स्पेसिफिक आंसर किया है. सब्जेक्ट से अपलोड पर है कि आपका वेग
प्रूव दैट नहीं फर्स्ट का है, फर्स्ट वन.
सेकंड
दोनों में भी वही है, सेकंड में भी वही है.
सेकंड पॉइंट बिलो रिकॉर्डेड फाइंडिंग.
और ये जो रोमन 3 जो आपका एडिशनल एविडेंस है, इसमें तो कुछ इट्स नथिंग गोइंग बियॉन्ड. बस हो गया, बात खत्म.
जो सेकंड है कि beyond the pleadings and evidences, what I mean to say that the defendant has not claimed that property and the court has recorded the finding.
Then the court should have decreed the suit without being satisfied about the title of the plaintiff because the defendant had not claimed anything over your property.
No, the plaintiff has not. The ground for non-suit is identity.
Identity, yes, it is. Show me.
Identity.
आप हमको बताइए.
But relating to identity, the judgment is
बताइए. नहीं. कौन सा आइडेंटिटी का जजमेंट आते हैं? एक तो दो अलग अलग कैटेगरी के प्लेंटिफ एक साथ ज्वाइन करेंगे, इसका क्या मतलब है? फर्स्ट सेट सेकंड सेट का कोई लेना देना नहीं है एक दूसरे से, कोई मतलब नहीं है।
एक तो बोलते हैं कि आप इतना क्लेम किए रिक्लेम किए,
हाँ।
ये बीच प्रोविजन ऑफ लॉ कोई प्लीडिंग नहीं है, कुछ नहीं। और सरकार से सीधा असेसमेंट करा दिए, उसी से टाइटल।
इसीलिए लोग टाइटल सूट में अपना डॉक्यूमेंट्स
इनका जो क्लेम सेटलमेंट का है माइनर के द्वारा, ये अपने कहते हैं कि माइनर हमारे फादर ने कराया।
उनका छोड़ दीजिए ना एक सेकंड, उनका राइट नहीं डिक्लेयर किया है ना, क्यों उनके पीछे पड़े?
तो लिखा गया है कि लिंक्स इन फेवर ऑफ द डिफेंडेंट, हर जगह ये लिंक्स इन फेवर ऑफ द डिफेंडेंट।
कोई फाइंडिंग अल्टीमेटली है?
यहां पे अपडेट कोड ने दे दिया।
अपडेट कोड?
हां दे अपडेट कोड ने दे दिया।
अपडेट कोड ने कहां कोई फाइंडिंग
कोड इनका
दे दिया। इसीलिए तो इसीलिए
फेल टू प्रूव
फेल टू प्रूव whether it is defendant is going to be favor
अरे भाई कहां लिखा है कि डिफेंडेंट हैज प्रूव्ड हिज टाइटल?
in which favor it leans।
नहीं आप लास्ट पैराग्राफ पढ़िए ना, देयर डिस्कस्ड
para 24
अगर ऐसा होता तो पार्टली अलाउ होता या कुछ होता, कुछ भी नहीं है।
लिखा therefore I discussed here above the plaintiff appellants have failed to prove their right as a whole suit whether it is the defendant is one in which favor it leans। टाइटल के लिए जो फाइंडिंग दे दिया है, फाइंडिंग तो डिफेंडेंट का बिना कर
अभी दिखा देंगे ना, वो तो अपना प्रॉपर्टी ही अलग करते हैं, तो इनका जो भी फाइंडिंग है वो इनके प्रॉपर्टी पर है, जिनका आपसे कोई लेना देना नहीं, उतना तो लिखा ही देंगे क्या है? Your title has not been there, title has not been
सीधा
declared.
लिखना है कि you have full right to prove your title। जहाँ से
फर्दर
अब एक्चुअली everybody has his own language। आप उसका आप बताइए ना,
लैंग्वेज हैविंग मीनिंग
नहीं लैंग्वेज
इफेक्ट
लैंग्वेज क्लियर है कि आपका कोई टाइटल नहीं,
लैंग्वेज हैविंग इफेक्ट
आप यू हैव कम टू पॉलिटिक्स
लैंग्वेज हैविंग इफेक्ट
नहीं कोई ये तो कल लिख रहे हैं कि हाँ आपका इनका कागज पत्र ठीक दैट उतना तो लिख ही सकता है, पूरा टाइटल डिक्लेयर कर दिया ऐसा।
आप देखिए ना यहाँ पे ये भी तो है,
तो आप मेरा टाइटल पर अगर मान लीजिए हमारा अगर हम अपना डॉक्यूमेंट जमा करेंगे तो कोर्ट उसको एग्जामिन करेगा, कुछ ना कुछ तो लिखेंगे। ये अपीलेट कोर्ट का एकदम पॉइंट ऑफ डिटरमिनेशन।
इनका रिटर्न आया, रिटर्न को कहा गया कि नहीं गलत है, फिर
नहीं बिल्कुल सही है,
दिखाते
वन में
हैं
उसका नाम दो कोर्ट का है
अलग रिपोर्ट आया
कहाँ
हाँ दोनों आया, दोनों पार्टी बीच कराए हैं, एक पार्टी कहते हैं सही है, एक पार्टी गलत है, दोनों का रिपोर्ट आ गया।
इतना हम लिखा देंगे that as per their written statement they have not claimed your property, खत्म हो जाएगा ये, इसका रिगर्स अपने खत्म हो जाएगा, है ना, इसका रिगर्स अपने खत्म हो जाएगा।
इस प्रॉपर्टी से नहीं अलग सेपरेट होगा कोई
इनका एक्चुअल में जो इनका जो इनका मुख्य क्लेम किया है ना कि ये इसमें 97-96 वाला भी सब नई क्लेम करके इसमें बोलते हैं कि इसमें आया होगा और ये इशू ऑफ डिमार्केशन है और वो चीज पर ये बोल नहीं रहे। मैं लिखा है इसमें तो पढ़ी तो होना चाहिए कि हाई कोर्ट से डिसीजन होगा इस पॉइंट पे,
तो हमने दिखा ही नहीं। मेरा वही केस है कि थर्ड केस कोर्ट
थर्ड केस कुछ नहीं है, फर्स्ट केस
ये इसी पे थर्ड केस लिख देंगे कि ये सब फाइंडिंग का कोई मतलब नहीं है, बिकॉज द क्लेम ऑफ द डिफेंडेंट वाज ऑन अ डिफरेंट प्रॉपर्टी ऑलटुगेदर। हो जाएगा आपका काम। देखिए
कि डिफेंडेंट को इस प्रॉपर्टी से मतलब नहीं है, कर दिया है।
हाँ तो खुद ही लिखिए अपने रिटन स्टेटमेंट में
ठीक
कि डिफेंडेंट को जो है इस प्रॉपर्टी से मतलब नहीं है और आपका तो प्रॉपर्टी बिल्कुल ही डिस्क्रिप्शन ही प्रॉपर नहीं है, तो खत्म। यही तो फाइंडिंग है ना, आपका प्रॉपर्टी का डिस्क्रिप्शन सही है,
डिस्क्रिप्शन लेकिन खाता प्लॉट बाउंड्री है।
ठीक।
ऑर्डर 723 से कहता है आइडेंटिफाइबल है।
सेकंड अपील नंबर 328 of 2016 for the learned counsel appearing on behalf of the parties. This appeal has been filed against the judgment and decree dated 30/3/2016 within bracket decree signed on 18/4/2016 bracket close passed by learned District Judge Roman 2 Garhwa in title appeal number 5 of 2011 affirming the judgment and decree dated 31/1/2011 within bracket decree signed on 21/2/2011 bracket close passed by the learned Munsif Garwa in title suit number 4 of 1991. The appeal was both the courts, the trial court had dismissed the suit. The first appellate court has affirmed the judgment of the learned trial court. This appeal has been admitted for final hearing by the order dated 27/9/2023 on the following substantial question of law. The learned counsel for the respondents at the threshold has submitted that none of the substantial questions of law arise for consideration in the present case, as they do not constitute substantial question of law at all. He has also submitted that so far as the additional evidence ought to be adduced through the interlocutory application is concerned, the same also does not help the appellant in any manner, as the same is of no use for identifying the property involved in the present case, and both the courts have passed judgment by holding that the plaintiffs have failed to get the property. The plaintiffs have not given proper boundary and identity of the property,
It's vague.
and the identity and description of the property is vague. He has referred to Order 7.
Order 7 rule 3.
Order 7, Rule 3 of the CPC. However, the learned appellant, while referring to the substantial question of law, has submitted that the plaint and the written statement is required to be seen as to what were the issues for consideration before the court. जी जी जी
Para 11, 12. There are no pleading written statement.
The learned counsel for the appellant has submitted that the boundary of the property involved in this case was duly identified, and no such objection with respect to the boundary was ever raised in the written statement, and therefore the learned courts were not justified in holding that boundary of the property was not
Property not identified.
was not justified in holding that the property itself was not identifiable, and consequently they were not justified in holding in dismissing the suit on that count. He has relied upon the judgment passed by Honorable Supreme Court reported in bracket 2015 bracket close 13 SEC 673 paragraph 10 and 11. While referring to the plaint, the learned counsel has referred to paragraph 1 to 4 and has submitted that there were two sets of plaintiffs. So far as the plaintiff first set is concerned, they were claiming that they had properties in plot number 78, more than 3 acres, having property about 10 acres in plot number 78, more than 3 acres in plot number 73, and about 1 acre in plot number 96. And rent was assessed, which was included in case number 105, in which correction slip was issued on 8/2/1965. The plaintiff
One thing I would like to
first
point
set
out, that he has pleaded that there are several blocks, 96, 97, 78 and 78. These are they just, but has given a common bond.
That's
I am claiming actually that 78. Actually he at all has.
we do not know contiguous थे नहीं थे
नहीं,
क्या
हम तो 78 ही कर रहे हैं।
आप 78
ये तो इनका vague boundary from the very
कोई
perimeter of
कोई बात just the learned counsel further submits that in plot number 97, that was the Bakas land, and the plaintiff first set had 2 acres of land, and the rent was assessed in their name, and the properties. The further case of the plaintiff first set was that they were recognized as occupancy rayats in cadastral survey bearing plot number 96, 97, 73 and 78 by the state of Bihar, and they were in exclusive possession of the property. So far as plaintiff's second set is concerned, it was the case of the plaintiffs that the plaintiff's second set had reclaimed 1 acre of land in plot number 78, for which rent was assessed in his name, and demand was opened by the state of Bihar and was being realized right from the date of vesting. The learned counsel submits that there were numerous proceedings under section, which included proceeding under section 144 CRPC and 145 CRPC, and ultimately between the parties, and ultimately the suit was filed. He has further submitted that in the plaint itself it was mentioned that the plot number 78 had total area of 27.25 acres. And no portion of plot number 78 was in possession of the defendant. The schedule of the properties are as under schedule A, B, C. तीनों को quote करें. The learned counsel submits that a written statement was filed by the sole defendant, who admitted the statements made in paragraph 1 to 4 of the plaint. Who stated that the statements made in paragraph 1 to 4 of the plaint are neither admitted nor denied, and plaintiffs be put to strict proof of the same. The inter se proceedings under section 140, it was not disputed that there were inter se proceedings under section 144 and 145 of CRPC. The plaintiffs claimed that property was settled. No, the defendant claimed that the property was settled in the year 1949 in her name, and the property was taken by her father while she was a minor. It was also denied that, it was also stated that no part of, sorry, it was also stated that no part of plot number 96 or plot number 97 was included in 3.50 acres which was settled in favor of the defendant. Sorry,
48 का question number 48 49 का है
48 का settlement है.
48 का this is a period.
Okay. 1948 का settlement. The learned counsel has also submitted that as per the written statement, the facts with respect to the properties has been mentioned in paragraph 15, and the defendant claimed that they were also having rent receipts. With respect to the property claimed by them, the learned counsel has drawn the specific attention of this court to paragraph number 15 with bracket F, and has submitted that the defendant claimed that they were in possession of the property settled with her in plot number 78, and also claimed adverse possession. The counsel has also referred to paragraph number 16 to say that the specific case of the defendant was that the plaintiffs have no land within the boundary of the land of the defendant. Paragraph 15 within bracket F and 15 within bracket 6 and paragraph 16 are quoted as under. The learned counsel submits that it was a specific case of the defendant, that there is no overlap between the case, between the claim of the plaintiff and the claim of the defendant.
As per the pleadings.
As per the pleadings of the defendant, he submits that under such circumstances there was no impediment on the part of the court to decree the suit in favor of the plaintiff. The learned counsel submits that although the boundary of the suit property was not specified by plot number, by details of plot number, etc., and no map was attached with the plaint, but the boundary mentioned was sufficient for the court, as no dispute with regard to identity of the property was raised by the defendant in the written statement. The learned counsel submits that under such circumstances, the learned trial court as well as the learned first appellate court have decided the case on the issue which was not involved with regard to identity of the property. And therefore, the substantial question of law, and therefore it suffers from perversity. He submits that the substantial question of law number 1 and 2 is accordingly be answered in favor of the appellants. With respect to substantial question of law number 3, the learned counsel has referred to the additional evidence. Correct?
3
Yahi 105.
Whether the appellate court will record illegal wrong find that this counts of this case number against the plaintiff say. This was not the case of the plaintiff second say that my demand, my assessment of rent was with respect to plot, with respect to case number 9.
Okay. With respect to substantial question of law number 3, the learned counsel for the appellant has submitted that so far as plaintiff's second set is concerned, it was never their case that their property claimed by them was involved in miscellaneous case number 105 of 105 dated 18/2/1965. But in spite of that, the learned court in कहाँ पे hold किया बताइए?
This document was not filed. appeal court.
In spite of that, the learned first appellate court has refused to grant any relief to the plaintiff's second set, inter alia, by holding that the proceeding in connection with miscellaneous case number 105/08.02.1965 was not filed, was not available on record. The learned counsel submits that the plaintiff second set by claiming property only in plot number only in plot number 78, area 1 acre. 1 acre, but the same had no relation with the aforesaid case of 1965, as per the plaintiff.
And plot number 97 having also no nexus with case number 105. 97 having also no nexus.
The learned counsel has also submitted that so far as the plaintiff first set is concerned, plot number 97 also had no nexus with the miscellaneous case number, with the miscellaneous case of 1965.
Despite that, whole suit nullified.
And in spite of that, the entire suit, the suit in its entirety has been dismissed. That's all. The learned counsel appearing on behalf of the respondents has opposed the prayer, and apart from the aforesaid objection with regard to substantial question of law, has submitted that if the description of property is not proper in terms of Order 7, Rule 3, then the suit cannot be decreed.
From the result of rent itself, the Lord will find that there are 3 or 4 plots. But the plot in question which is in dispute is actually 78, which pertains to me.
The learned counsel has also submitted that although in the plain there are numerous plots, but so far as the defendant is concerned, they were only concerned with portion of plot number 78, and they had stated that the portion of plot number 78 being possessed by the defendant was different from the claims made by the plaintiff. The learned counsel has also submitted that it is for the plaintiff to get the property identified, and in absence of proper identity of property, the right, title and interest cannot be declared. And has again referred to Order 7, Rule 3 of CPC.
Apart from the document which was the anchor, seat anchor document that they did not produce before the trial court or the appellate. Now at the second appellate they say they are producing those documents which has now no sense.
No sense, and it is not helping them also.
Not helping us.
The learned counsel for the respondent
Apart
has, yes.
Apart from that, my friend is relying upon the first set he was saying, but their claim will also be that they have acquired one, but they claimed one acre. For that, what document they have produced? In absence of document, can there be any decree?
Matching or not matching, that is another. But rent was assessed. My
no document, original document for reclamation.
regarding portion.
Yeah,
where my submission.
कोई बात नहीं, अच्छा वो तो उतना में नहीं जाने का जरूरत. The learned counsel for the respondent has also submitted that the document which is sought to be adduced as additional evidence at second appellate stage cannot be accepted, as there is no cogent explanation for not producing the said document at appropriate stage. It was neither produced at the stage of trial nor produced at the stage of first appellate court.
In the case of the Ibrahimuddin, Union of India versus Ibrahimuddin, that judgment, my lord, the Honorable Apex Court has said that such documents cannot be allowed, my lord, to patch up the lacuna.
The Learned Counsel has relied upon the judgment passed by the Honorable Supreme Court reported in. ये सब आपके खिलाफ हम यूज करेंगे अप्रोच सेकंड अपील में यही रोज सेकंड अपील में एडिशनल सब्सटेंशियल क्वेश्चन ऑफ लॉ और एडिशनल एविडेंस has relied upon the judgment passed by the Honorable Supreme Court reported in bracket 2012 8 SSC 148 and has submitted that additional evidence cannot be permitted to be filed only to fill up a lacuna. He has also submitted that otherwise also the additional evidence is of no consequence as the same does not clear the boundary of the property claimed by the plaintiff, which is the reason for dismissal of the suit. He has also submitted that the learned courts have neither decided the suit in favor of the plaintiff, nor the same has been decided in favor of the defendant.
There was no occasion to decide in favor.
And there was no occasion to decide the suit in favor of the defendant, as the defendant was claiming, and the other observations has no relevance. He submits that the defendant specifically claimed that the property of the defendant is different from that of the plaintiff's.
It is well settled that the plaintiff has to stand on his own leg.
He has also submitted that the law is well settled that the plaintiff has to stand on his own legs.
Right law.
Okay. To this, the Learned Counsel for the appellant has submitted that the Learned First Appellate Court has made an observation that the plaintiff has failed to prove the right title over the suit land. Rather, it is the defendant in whose favor it leans. The Learned Counsel submits that when the defendant was claiming that they had completely distinct property, there was no occasion for the Learned First Appellate Court even to make an observation to that effect. Had the Learned First Appellate Court taken care of the pleadings of the parties, there was no such occasion. That's it.
And the Learned First Appellate Court has also observed that the boundary and khata plot of schedule A is specified, but schedule B and C are not mentioned.
The Learned Counsel has also submitted that the First Appellate Court has given conflicting finding. On the one hand, the court has observed that the boundary of Schedule A is specified, but the boundary of Schedule B and C is not specified, and ultimately dismissed the suit under Order 7, Rule 3 by holding that the boundaries are vague and do not satisfy the requirement of Order 7, Rule 3 of CPC. And the pleadings of the plaintiffs is defective.
In absence of pleadings of the parties.
After hearing the Learned Counsel for the parties and going through the plaint and the written statement, this court finds that though the plaintiffs claimed certain property in plot number 78, 73 and 96,
And 97.
which was in connection with, which was subject matter of case number 105 of in the year 1965. But with respect to plot number 97, no such relation was there with the said case. so far as the plaintiff second set is concerned, they claimed only 1 acre in plot number 78. Even that did not have any connection with case number 105 of 1965. It is so far as the description of property involved in the case is concerned, admittedly the boundaries admittedly the plaintiff was claiming portions of property. Portion है ना सब? Portions of property in
क्लियर बहुत सारा क्लियर तो नहीं है 78 तो पोर्शन है
78 the portion है. It is not in dispute that so far as plot number 78 is concerned, the plaintiffs were claiming portion of the property, and so far as plot number 96 and 97 is concerned, it is not clear as the same was part of the property or same was the entire property. नहीं है ना clear?
रीडिंग
Red boundary.
हाँ?
Red boundary.
Just.
डिस्प्यूट है
However, the plaintiff number 1 and it has not been mentioned in the plaint as to what was the total area of plot number 96 and plot number 97, although the total area of plot number 78 has been mentioned. The boundary which has been given to Schedule A does not give any description.
97 के बाद से लिखा हुआ इंक्लूडिंग 2 एकर्स ऑफ प्रॉपर्टी 97 इंक्लूडिंग क्या
Boundary common.
इंक्लूडिंग 2 एकर्स
इंक्लूडिंग 2 एकर्स इसका क्या? और आप क्लेम कितना किए हैं? 0.759. तो फिर the plaint also reveals that in plot number 97, with respect to plot number 97, area of 2 acre has been mentioned, but the claim is only 0.59 acres. Correct? है ना?
That is written para 2 of the claim.
हाँ, yes. This court finds that the Honorable Supreme Court, by considering Order 7, Rule 3 of CPC, has observed that the property can be identified by boundaries or by number in public record of survey settlement, even by plain map showing the location of the disputed immovable property. This court finds that the description of the property, which has been the boundary of Schedule A property, the boundary of Schedule A, B and C property does not refer to any plot number / khata number or part of plot number / khata number. Rather, it only mentions the name of the persons. It is also not clear as to whether these properties are contiguous to each other or not. The khata numbers are also different. With respect to plot number 96, the khata number is 25. With respect to plot number 97, khata number is 3. And with respect to plot number 78, the khata number is 1. Although the thana number for all the property in the schedule is 199. This court finds that the learned trial court, on the basis of the pleadings, had framed the following issues for consideration. Include the aforesaid issue included as to whether part of plot number 96 and 97 amalgamated with 3.50 acres of defendant in plot number 78, and also whether the defendant has acquired rayati, right title and interest through settlement in the year 1948 over 3.50 acres of land of suit plot number 78. The learned trial court has considered issue number 8, 9, 11, 12 and 13 together. And has recorded that plot number 78 is a very big plot, and has also recorded that the documents of the plaintiff in connection with khata number 25 and khata number 1 were also in parts and consisting of several plots. The court ultimately recorded that the boundaries of the property that there was no detailed document available The court also recorded that the defendant had also produced document with respect to demand for the plot number 78, khata number 1, area 3.50 acres. The court ultimately recorded that there was no exact physical possession of the land in question in favor of the plaintiffs. Rather, the area and boundary as submitted by the plaintiff itself appeared to be very much confusing and doubtful. And also observe that it could not be said that without measurement of the physical position to locate the specific boundary of the land, it would go in favor of the defendant. And though it could not be denied that the land of the plaintiff and defendant appeared as per the evidence within plot number 78. The court also held that there was no specific demarcation with plot number 78, and it was not possible to ascertain the exact portion out of big plot number 78 as to, without clear demarcation, neither of the parties could claim the suit property for them. Primarily, the learned trial court considered the fact that the defendant was claiming the property only in plot number 78 and no other plot, and recorded that in absence of proper demarcation and boundary, it was not possible to decree the suit. This court finds that the learned trial court had taken into consideration the fact that the defendant was claiming the property only in plot number, or claiming the property only in portion of plot number 78, and the boundaries etc. could not be ascertained on the basis of the evidence from the descriptions given in the plaint and on the basis of the evidences adduced on behalf of the parties. The trial court neither decided the right title interest in favor of the plaintiff nor decided the same in favor of the defendant, though the suit was dismissed. So far as the learned first appellate court is concerned,
Defendant title had no, what had no, whether to decide.
so far as the learned first appellate court is concerned, the following two issues were framed. Internal page 11 mein. And the learned first appellate court considered the oral and documentary evidences, including the evidence of the plaintiff themselves, who were not able to give the exact boundary and location of the property even in their oral evidences. The court recorded that the three schedule of land in the plaint, namely ABC out of schedule A, is the suit land which includes B and C. The court also recorded that the suit land under schedule A, which were specified with specific boundary, but schedule B and C, which were included under schedule A, have their different boundary, meaning thereby the court was of the view that the boundaries, though the schedule A and schedule B property constituted the entire schedule A property, but the boundaries did not match to ascertain the property. And ultimately the court came to a conclusion that the suit land were vague, as not specified in boundary and area as required under the mandatory provision of Order 7 Rule 3 of the CPC, and the pleadings of the plaintiff slash appellant was defective one. ये पैरा 7 कोट करेंगे इसका, ठीक है, पूरा ही A and B दो पार्ट में. The finding is in para 7 within bracket A, which is quoted as under. So far as the finding with regard to point number B is concerned, the same has been decided by paragraph 7 within bracket B. and the court recorded that although specific reference was made in the plaint,
What has taken adverse?
sorry,
What has taken adverse?
court has taken adverse inference on account of non-production of the records relating to case number 105 dated 8/2/1965, which was said to be the basis of the claim of the plaintiff. However, this court finds that the entire claim was not based on the said document
of the plaintiffs.
of the plaintiffs. As rightly pointed out by the learned counsel appearing on behalf of the appellant. However, the same does not have much bearing in this case. The reason being that the bone of contention was plot number 78. And therefore, the court was under an obligation to decide only in connection with plot number 78, as the defendant did not raise any dispute with other plots at all. The learned first appellate court recorded that the plaintiff has failed to prove their right title over the suit land, and also observed that it was a defendant in whose favor it leans. However, no clear finding has been recorded in favor of the defendant as well.
There was no
And there was no occasion to decide the right title and interest of the defendant with respect to a property which the defendant claimed to be totally distinct from that of the plaintiff. Considering the substantial question of law involved in this case, this court finds that the learned courts have not committed any perversity and have rightly focused on the plot number 78, which was the real bone of contention between the parties, and have not returned any finding in favor of either parties
because of vague
because of the vague description of the property. The findings are not beyond the pleadings of the parties. It is sufficient to observe that
somewhere beyond bleeding, somewhere कहीं ये तो है
if there is any aberration in connection with considering miscellaneous case number 105 dated 8/2/1965, then the same has occurred primarily on account of the same has no bearing in the matter. However, it is sufficient to observe that the said case was not relatable to the entire suit property, and the defendant second set, the property of defendant's plaintiff second set, and portion of the property of defendant first set has no relation. Plaintiff first set had no relation with the aforesaid proceedings, as is apparent from the plaint itself. Consequently, even though the learned first appellate, the learned court have given incorrect finding on the aforesaid aspect while considering the miscellaneous case number 105 dated 8/2/1965, but still the same has no bearing in the matter as the description of the property remains vague. In view of the aforesaid findings, the substantial questions of law are answered as aforesaid, and this appeal is accordingly dismissed with the aforesaid observation. आइए तो हम तो ऑलरेडी रिजेक्ट ही कर चुके हैं. सो फार एज आइए नंबर हम फॉर्मली नहीं रिजेक्ट किए हैं, उस दिन ऑर्डर अपलोड किए थे हम. हाँ, दैट इज इम्पोर्टेंट. सो फार एज द इंटेलेक्चुअल एप्लीकेशन इज कंसर्न्ड, this court finds that the appellants have not given any acceptable explanation for not producing the said document at the appropriate stage, and further considering the plaint and the findings recorded by the court that the description of property do not conform to the provisions of Order 7, Rule 3 of CPC, the said document is not required by the court to answer the substantial question of law involved in this case. I will dismissed. शुरू करने से खत्म हो ही जाता है, टाइम लग जाता बहुत. चलिए, करेक्शन करने में जो आपको टाइम लग रहा है हमें को पता है. I know you must be. कहाँ से एम्बार्गो? देखिए आपका सब चीज ओपन कर दिया, आप देखिए नहीं, हम डिसमिस किए विद एफोर्सेड ऑब्जर्वेशन. ठीक है, आपका सब चीज खोल दिया, आप जाके फ्रेश शूट कर दीजिए.